On October 12th, Vice President J.D. Vance said President Trump was looking at all his options when asked if the Trump administration was considering invoking the Insurrection Act. Hello, friends. I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. This week, we'll discuss the history and meaning of the Insurrection Act, which authorizes the president to deploy U.S. military domestically for law enforcement purposes. To help us explore this important topic, we have two of the leading scholars on the Insurrection Act, national security law, and federal military power. William Banks is a Syracuse University College of Law Board of Advisors Distinguished Professor and Professor Emeritus of Public Administration and International Affairs in the Maxwell School. He's written extensively on national security, emergency powers, and military relations, and he is most recently the co-author of Soldiers on the Home Front, the Domestic Role of the American Military. Bill, it is wonderful to welcome you to We the People.
It's good to be with you, Jeff, and with Laura Dickinson, one of the most prominent scholars in this field. What a team.
What a team indeed. And thank you for introducing Laura Dickinson, who is the Lyle T. Alverson Professor of Law at the George Washington University Law School, where she focuses on national security, human rights, and the law of armed conflict. She's the author of Outsourcing War and Peace, and she contributes regularly to the national security blog, Just Security. Laura, it's wonderful to welcome you back to We the People.
It's great to be here. Thank you for having me. And of course, it's great to be here with Bill Banks, who is not only a preeminent scholar in this field, but I would say perhaps the preeminent scholar on the history of the Insurrection Act.
Wonderful. Well, we're all looking forward to learning from both of you, and let us begin with the history of the Insurrection Act. Bill, you have a 2009 article in the Journal of National Security Law and Public Policy where you discuss the English and American pre-ratification history, and through a close reading of the Constitution, you argue that only extreme threats, invasions and insurrections against the national government, or other direct threats to Republican government would justify a federal military role in the absence of a state's request. Tell us about the history and original meaning of the Insurrection Act.
That's a good, very broad, but very rich question, Jeff. And I think it's probably worth mentioning for a moment that we learned how to do this, as it were, from the English. Like so many other parts of our system and our government and our way of doing things, the English, of course, until the 17th century, had very little restraints on the military in England and very little in the way of restraints on the authority of the king. But 1688 forward, the Petition of Right and the English Bill of Rights eventually began to increase the parliamentary role and the parliamentary power over the use of the military against English citizens. When the system then made its way into the colonies for a good number of years before the Revolutionary War, the Crown was able to issue something called writs of assistance. And writs of assistance allowed the colonial governors to approach a court, get a writ that would be easily signed by a colonial judge, also in the English system, to essentially ransack colonists' houses, arrest them without cause, to take their papers, detain them for periods of time. It was really a very arbitrary system. So, as many of your listeners will know, when it came time for the Declaration of Independence, one of the chief complaints, perhaps the chief complaint that we voiced in that document, was that the English had allowed the military to become superior to, independent of, and superior to the civilian power in the colonies. And that, of course, led directly to our independence and then to our framing of our own government, eventually Articles of Confederation and then the Constitution. And we put some checks in place to make sure that sort of outsized authority of the military and civil society would not manifest here.
Thank you so much for helping us understand that history. Laura, tell us more about the history and take us into the framing era when, in drafting the Insurrection Act in 1792, the founders were moved by examples of domestic insurrection, in particular Shays' Rebellion in Western Massachusetts, which was such a spark for the calling of the Constitutional Convention.
Yes, to start, I just want to echo what Bill has said about the colonists' concern about the excesses of military, especially when they are doing law enforcement type functions. And so I think it's important to understand some key provisions of the Constitution before we look at the text of the Insurrection Act, because I think you can see in our constitutional text and history a real, again, concern to limit the extent to which the military would engage in direct law enforcement functions outside a severe type of emergency on U.S. soil. And the Insurrection Act, I think, needs to be seen in that light because it's an exception and it does allow law enforcement functions to be done by the military. So just looking at the constitutional text, which I think really grew out of this concern, some key provisions include Article 1. So Congress's power in Article 1 to regulate the militia, to call forth the militia, of course, being a historical name for what we now know as the National Guard, but also to regulate the armed forces and to appropriate money for the armed forces. So these are really important powers that are vested in Congress, which also, of course, has the power to declare war. So even though the president is the commander in chief of the armed forces, Congress has key powers to regulate the armed forces and the militia. Then we also have Article 4, Section 4 of the Constitution, which is sort of what is referred to often as the guarantee clause, which is that the federal government is supposed to guarantee a Republican form of government and has the obligation, arguably, to use the military to protect that in the states, but then allows, upon state request, the use of the military in cases of severe violence. And Bill has written extensively about the meaning of this clause and its limits. And then finally, I would note the 10th Amendment, which reserves to the states powers that are not given to the federal government. And that's really understood to be policing and things of this nature. So when you look at that backdrop, what you see is a preference for Congress to regulate how the militia are used and regulated, how the military is used and regulated, and a reluctance for that power to be invoked, except in really extreme circumstances. So the Insurrection Act, which does give authority to the president to federalize the military on U.S. soil, has to be seen in that light.
Thank you so much for that. Bill, you, like Laura, emphasize those two crucial constitutional texts, the calling forth clause in Article 1, Section 8, which authorizes Congress to provide for calling forth the militia to execute the laws of the Union, suppress insurrection, and repel invasion, but does not, as you emphasize, authorize a response to domestic violence, and also the Republican form of government clause, Article 4, Section 4, which obligates the federal government to guarantee a Republican form of government to each state to protect the states against invasion and to protect them against domestic violence, but only after a request from the governor or legislature. That's the protection clause. So in other words, you argue that the Constitution requires a gubernatorial request for protection against domestic violence and does not authorize a federal response to domestic violence without that request. Tell us more about that and about the ratification debates, which reinforce your conclusion that the Insurrection Act of 1792 embodied a similar limitation.
That's really rich history, and the soup gets thicker, as we say, when we begin to probe what was going on at ratification. And then in the first few years in the 1790s, when Congress actually took up the issues. There's the bottom line, I think, is I would maintain that the Insurrection Act, that we call it by that name now, but the original legislation, 1792, and going forward, has been unconstitutional because it allows the president unilaterally to use military force domestically following domestic violence when there has not been a request from a state, a governor or a state legislature. I'm sort of out there alone on that point of view, I think, in the article I wrote some years ago, but I'll stick to my guns. The history, was that at the time of the framing, the militias in the colonies and then the states were thought to be a great security blanket in the states. They weren't so instrumental in the Revolutionary War in many respects, but they didn't represent the fears that many Americans had about the presence of a standing army. The militia were our neighbors. They were our friends. They were members of our communities. They're farmers. They're merchants. And they could be called out to respond to crises in the states. And indeed, that's the vision that we have of the National Guard today. They're safe. They provide security. They keep us well. But we were very much inclined at the beginning not to allow for a standing military, so the mechanism was set up, much as Laura described it in those provisions of the Constitution. The problem that arose in the 1790s and then going forward is that when Congress enacted the Calling Forth Act in 1792 and then amended it a few times in the coming years, 1795, 1807, they started pretty strong and they built in restraints on the president's exercise of discretion. He had to get a judge's approval before he could respond to the Whiskey Rebellion in Western Pennsylvania in 1795. He was term limited. He had a sunset of no more than 2 years, and he had to issue a very careful proclamation requiring and giving some time for the so-called insurrectionists to cease and desist. The Whiskey Rebellion, you learn about this in fifth grade from your civics teacher. And indeed, the Whiskey Rebellion turns out to have been probably a big overkill on the part of President Washington, sending thousands of troops from around the different states in surrounding Pennsylvania to round up maybe 150 tax protesters, in effect, who were protesting the imposition of levies on spirits in Western Pennsylvania. How dare the government tax my whiskey? And the violence was very light in that incident. Once the federal presence and the numbers of federal forces were made clear, the alleged lawbreakers basically gave up the cause, and the soldiers went home and everybody moved on from there. But the law allowed the president to invoke the use of a call up a federal military force with a very low predicate, a very low threshold.
Laura, tell us how the Calling Forth Clause and the Guarantee Clause were interpreted by the framers and how it reflected this limited understanding of federal power to respond to domestic violence.
Yeah, so I think it's important to understand that the framers really did interpret even the authority of Congress to provide for the calling forth of the militia in a fairly narrow way to include pretty extreme circumstances. There's actually a recent judicial decision in Illinois involving the federalization of the National Guard, Judge Perry's decision, which discusses this history. For example, the framers, they really wanted this clause to be used in circumstances which were very, very extreme. And this included both Federalists and anti-Federalists. For example, you have Madison, who really moved for the removal of language that would have been much broader in the calling forth clause, language that would have allowed the militia to be called forth to do law enforcement. And we have Patrick Henry, who expressed fears that the militia clause might open the door, if it allowed Congress to bring the militia to do law enforcement, that would open the door to despotism. And anti-federalist Henry Clay expressed similar concerns, and he asked the Federalists, quote, for instances where opposition to the laws did not come within the idea of an insurrection, of course, being a really extreme event. So I think you can see from these discussions of the calling forth clause that there was a concern to sort of place limits on when even Congress could authorize the militia to be federalized and used for law enforcement.
Bill, tell us more about the history and expansion of the Act. In the early 19th century, it was in 1807 that President Jefferson asked Congress to expand his authority to respond to a rebellion in Vermont against his hated embargo, one of the many examples where Jefferson switched his view on federal power once he became president, having previously called for clemency for the Whiskey Rebels and the Shays Rebels. He suddenly discovers the virtue of expanded executive power once he becomes president, as I discuss in my new book, The Pursuit of Liberty, which is out this week. Tell us what Jefferson had in mind when he expanded the Insurrection Act in 1807, and then how it was invoked leading up to the Civil War, when it's invoked in response to an Arizona-Mexico border dispute in 1831, a slave rebellion in 1831, labor dispute in 1834, and then, of course, most significantly, the secession of Southern states in 1861.
That's a rich question, Jeff, and congratulations on the new book, by the way. That's great.
Thank you.
So even before the 1807 change in the legislation, that's about the time, by the way, that the legislation began to be known as the Insurrection Act. There was a change also in 1795. You remember the original 1792 law that Washington utilized to pursue the Whiskey Rebellion. In 1795, Congress passed nearly identical legislation, but if you read the fine print, you would see there were a few changes. The sunset provision was gone. The legislation eliminated the requirements for a judge to sign off on the operation in advance, and the prior presidential proclamation to disperse was also eliminated. So the terms that were set out in 1795 are really the terms that stayed in the law until the Civil War for some pretty major reforms. The 1807 law that you're referring to, Jeff, really did one very significant thing because it allowed the president to deploy regular military, not just members of the militia. And this was a sea change. Circumstances where state militias had been authorized by 1792 or 1795 legislation could now be supplemented or even supplanted by regular military. Presidents could deploy professional soldiers, in other words, where there was doubt that local militias could overcome, for example, local biases in the situations that you described, Jeff. So when you put those together, 1795 and 1807, those revisions really unleashed the president as a domestic commander-in-chief, if you will. And the law was not further reformed then until the Civil War.
Laura, tell us about those Civil War reforms. There was a significant expansion of the act in 1871 as part of the Ku Klux Klan Act, one of the most significant of the Reconstruction era expansion of federal authority to respond to mob violence and lynching and the subversion of Black civil rights. The Supreme Court amazingly struck down parts of the Ku Klux Klan Act by saying that it was only allowed to respond to private violence and required some state action in order to satisfy the Constitution. And yet it allowed the expansion of the Insurrection Act to stay on the books. So how was it significant and what was the effect?
Yes, after the Civil War, during that period when the KKK was terrorizing the Black population with the support of local officials. The Insurrection Act was amended to give greater power to deploy federal forces without the consent of state and local officials. So it's an important example of why that authority is needed. You mentioned the 14th Amendment. I mean, the 14th Amendment is also, I would argue, part of the authority for that expanded Insurrection Act beyond the other authorities that were mentioned. And in particular, there's language with respect to deploying forces in order to protect people's civil rights. So that's through the authority in part of the 14th Amendment, which when you mentioned state action, there is an argument that the authority to use that part of the Insurrection Act only kicks in when there has been such a breakdown in law enforcement locally that it's effectively state action in the sense that there is no law and order. So, and that is something that the U.S. government legal memos has argued with respect to the Insurrection Act. So that's one theory of when the Insurrection Act can be used.
Bill, you note there were amendments to the Insurrection Act both during the Civil War in 1861, where Congress eliminated the requirement that before military force could be used, the powers of federal marshals had to be shown inadequate. And then the important changes in 1871 in the Ku Klux Klan Act, which you argue exceeded constitutional limits on the power of the national government imposed by the Protection and Calling Forth Clause. Tell us about those important Civil War era changes and how you think they violate the Constitution.
Well, the last point about the constitutional violation is my hobby horse, that because the president was allowed to respond in the event of domestic violence without a state request, it ran right afoul of the Article 4, a provision that Laura described earlier, the so-called Protection Clause. There were no state requests. You might forgive the Congress in 1861 in the Lincoln Law, right at the outset of the Civil War, needing to give President Lincoln, every ounce of authority he could muster to save the nation. Okay. By the time of the Ku Klux Act in 1870, the breadth of the language in that act was, quote, insurrections, domestic violence, or combinations intended to deprive anyone of the rights protected by the Constitution. So the good news was that soldiers could help former slaves exercise their new rights. And that was a very, of course, foundational step in our redevelopment after the Civil War, including the right to vote after the 15th Amendment. The Ku Klux Act did not require that civilian law enforcement be exhausted before deploying troops. That's a shortcoming. And indeed, that we've seen that, from throughout the history of the act, now known euphemistically as the Insurrection Act, and that defect perseveres today.
And Laura, perhaps you could also respond to the question. Bill acknowledges that his view that the expanded Insurrection Act is unconstitutional is unusual. Do you agree that the Civil War Congress exceeded the Constitution in the Ku Klux Klan Act? And then tell us about how the act was actually deployed during Reconstruction. It looks like there were a series of invocations against white supremacist insurgency in 1871. In 1873, after the incredibly violent election in Louisiana, in 1874, after the massacre in Vicksburg. These seem like virtuous invocations of the act all the way up to 1876 in response to white supremacist paramilitaries in South Carolina. Wasn't Congress arguably right to expand federal power in this way?
Yeah, so I would say I don't agree with Bill. I think he makes an important argument, but I don't agree with Bill. What I would say, though, is that although the text of the statute is broad, and I think there was constitutional authority to expand the scope of the act that comes in part from the 14th Amendment, Bill's argument rests primarily on the provisions of the Constitution, the original provisions of the Constitution. I think we have to look at the Constitution in light of the 14th Amendment after the Civil War. But what I would say is that Bill's arguments, the understanding of the framers and the understanding of the 14th Amendment itself, counsel in favor of a narrow interpretation of that seemingly broad statutory language. So that even though the statutory language seems broad, and I just want to draw attention to the language in what is now Section 253, which basically allows the president to act without a state request to suppress, again, insurrection, domestic violence, unlawful combinations, or conspiracies of various kinds. If it opposes or obstructs the execution of U.S. law, or hinders the execution of the law so hinders it so that people are deprived of their constitutional rights. The way that this has been interpreted by the U.S. executive branch pretty consistently, even though this could be read quite broadly, it should be read narrowly against this constitutional backdrop to apply only when law and order has completely broken down as a last resort, or to enforce a federal court order over the objection of state officials. So if we look at the use of the act in the Reconstruction era, in this period when you had the KKK running rampant in numerous southern states that you mentioned, that is a situation where law and order had completely broken down and where it was being used as a last resort. So it's an example of this, it being used, but in a way that I think is clearly permitted by the Constitution as amended under the 14th Amendment. I think that if you extend it to other situations like just ordinary policing and the like, I think there's a case to be made that the statute would not allow that, and that the constitutional backdrop would not allow the statute to be read in that broad a way. Not everyone agrees with me on that point, but that's what I would say. And that's what the U.S. executive branch has long said in its own internal legal memos produced by the Department of Justice Office of Legal Counsel.
Well, you've both focused on the broad language of Section 253, which again allows the president to act if he or she deems it necessary to suppress in a state any insurrection, domestic violence, unlawful combination or conspiracy. If, I won't read the whole thing, but the point is that if it opposes or obstructs the execution of the laws of the United States or impedes the course of justice under those laws, and although you disagree about whether that's constitutional or not, you agree that it should be read narrowly to protect responses to domestic violence that don't pose serious threats to the execution of the laws of the United States. Bill, tell us now how the Insurrection Act was applied in practice throughout the 20th century and the late 19th century. We've talked about the Civil War period. I'm just reading from the 30 invocations of the Insurrection Act throughout history, and I won't read all of them, but it is striking to call them out. 1877 railroad strikes in multiple states, gang violence in Arizona in 1882, riots against Chinese citizens in 1886, strikes. There's a lot of labor violence in the late 90s. Strikes and uprising in 1914 in Colorado, strikes and uprising in West Virginia in 1921, 1932, Douglas MacArthur and the Bonus Army. The protest is suppressed, although the act was not, in fact, invoked. And then race riots in Detroit in 1943, and then we're into the civil rights era significantly. Eisenhower at Little Rock calls out the 101st Airborne. And then in response, here I am going all the way up to the present, but we're almost there. Then we have race riots at the University of Mississippi responding to racial integration. Governor of Alabama is responded to by President Kennedy in '63, and President Johnson invokes it a couple times, including at Pettus Bridge. So what does that tell us about whether in practice presidents have read the act narrowly or not?
You've done all my work for me, Jeff.
Sorry, no, that was Wikipedia, actually, but it was good to get it on the table.
So that there are like two big buckets, if you will, the labor management relations, and consistently the troops were deployed beginning in 1877 on the side of management to help break strikes. And they were utilized fairly often. There was a nationwide railway strike. There was a big postal strike. There were strikes in major cities around the United States, and presidents beginning with Hayes and then later regularly deployed military without much hesitation there, pursuant to the Insurrection Act. And as race became an increasingly modern problem in the 20th century, there too. But as you pointed out toward the end of your list of examples, tables were turned because presidents, beginning with Dwight Eisenhower in 1957 in Little Rock, Arkansas, began to deploy troops to help Black kids get to school. And President Kennedy did the same. President Lyndon Johnson did the same in southern states, Alabama, Mississippi. So the tool, if you will, of a military force was used for good. Was used not to suppress a riot, but to send locals home so that the civil rights could be fully realized by the citizens in their states. It was ironic, wasn't it? In '57, for example, in Little Rock, Governor Faubus had deployed the state's National Guard throughout Little Rock to keep the kids from getting into the school. Eisenhower sent those National Guard forces home, brought in new forces, and did the opposite, escorted the kids to school. And, there's wonderful footage of all of this that you can see today that's a reminder of the struggle for civil rights. So getting to the present time, as we all know, the last time the Insurrection Act was invoked was in 1992 in Los Angeles. It was a unique circumstance that Rodney King had been beaten by police about a year before, and the officers who were charged with assaulting him, nearly beating him to death, were tried in Los Angeles, and the verdict came out, and it was acquittal. Rioting broke out in Los Angeles, and it got bad very quickly. The rioting spread throughout good chunks of the city. There were fires, there was looting, there was a lot of fighting, there was assaults on police and local National Guard that Governor Pete Wilson had deployed. And after a few days, the rioting was getting worse and sections of LA were burning. Governor Pete Wilson called President George H.W. Bush and made a request. President Bush, would you please invoke the Insurrection Act? He didn't say that, I imagine. He said, help. We need more military boots on the ground here in Los Angeles. And the president obliged right away, sent Marines and Army from bases near Los Angeles who worked together with the National Guard in California to eventually, it wasn't easy, to suppress the rioting that was going on in LA. So Bush H.W. Bush invoked the Insurrection Act. He followed the procedures. He issued the proclamation. And arguably, it made a terrible situation a little less bad.
And Laura, I won't read the list again, but as Bill has so well summarized it, it seems like the act has been invoked in response to two separate strains throughout American history. First, there's white resistance to federal power, as Jefferson Cowie puts it, including the white supremacist insurgencies in the South during Reconstruction, the Ku Klux Klan terror of the 1920s, and then in the Civil Rights era, Little Rock, Selma, and so forth. And then there's a separate strain of Black resistance to state and federal power, beginning with slave rebellions in Virginia, suppressed by Andrew Jackson, and then the protest against racism, suppressed by FDR, Lyndon Johnson, and most recently George H.W. Bush in '92. Broadly, have these invocations of the Insurrection Act been appropriate or not?
Well, I do think they've been appropriate, but what I would note is that all of these are this is very limited, right? I mean, when you mention 30 instances, it sounds like a lot, but that's 30 instances in our nation's history. That's not that many instances overall. And in each case, the invocation dealt with pretty severe violence, right? Again, where either law and order had completely broken down and it was a last resort, or to enforce a federal court order over the objection of state and local officials. So if you look at, to desegregate the schools, right, that's where state and local officials were refusing to follow what was a clear federal court order to allow those kids into the schools. And so that's a very narrow kind of situation where it would be invoked. And I would also note that in a number of these instances, it was at the request of the governor, as Bill notes, for those severe riots in LA. That was at the request of the governor, and there are other instances where it was at the request of the governor. So it's really a limited authority. And I would also note that during the protests around the killing of George Floyd that erupted in 2020, when President Trump reportedly wanted to use the Insurrection Act, many people around him said, no, this is not that kind of instance because it should only be used as a last resort when law and order is completely broken down. So, for example, General Milley, Secretary of Defense Esper, Attorney General Barr, reportedly all said to the president, this is really not the kind of circumstance in which the Insurrection Act should be used, historically has been used. So I just want to note that, these instances were pretty severe instances where you had serious violence occurring, or again, to enforce a federal court order over the authority of state and local officials. So the other thing is that when it has been invoked, it's been invoked for a narrow geographic area, and for a limited period of time. It's been kind of deployed, kind of, as some people say, like a scalpel, right? And so not a broad authority. Presidents across both political parties have been very, very cautious about this. And one last thing I would note that was brought to light during the 1992 invocation of the act, it doesn't always go well. I mean, I think those federal forces did help, but there were also instances where there were serious problems with the lack of training by the federal forces in how do you do law enforcement, how do you work with law enforcement, confusion about the kinds of orders regarding the use of force that I think highlight the challenges of using the military, even beyond what the statute might permit, the challenges of using the military in a situation like this. There can be a lot of confusion because, of course, whether we're talking about the active duty military or the National Guard, many of them don't get training in how to do law enforcement type functions. Some National Guard do, but most of them don't get training. That training is not consistent, and it's not as extensive as the kind of training that police officers would get. And so it can lead to tremendous confusion and potential abuses of force.
Bill, do you agree with Laura that presidents in practice have invoked the act prudently, and tell us about the debate in 2006 when President George W. Bush asked for an expansion of the act in response to violence surrounding Hurricane Katrina. Congress did expand it, but then in response to protests by all 50 governors, Congress revisited the expansion and repealed it in 2008.
That's right. I do generally agree with Laura that the the historical record, particularly in the 20th century, has been one of moderation. I think some of the late 19th century deployments were pretty much heavy on the side of the management in a labor management context. But by and large, the 20th century has been good. And as she points out, 30 times in 250 years isn't a lot. And the last deployment, 1992, now 33 years since that. And that, as she pointed out, that was for a limited period of time in a very limited geographic area. And indeed, all hell had broken loose in LA. Things were really bad, and the governor was truly unable to quell the violence there. I think, what's happened is that, as we know, the language of the act today, sections 252 and 253, have been around, gathering dust for a long, long time. There's been no serious effort by Congress to reform them, although very many groups locally in Washington and elsewhere have offered models for revision of the Insurrection Act, which would tighten the reins, if you will. What happened in Katrina is that when the storm hit, the federal government, President George W. Bush's administration and his FEMA were very unprepared. The storm came quickly. There wasn't a lot of warning, but it took 3 or 4 days before there was any significant federal response. The governor of Louisiana was a Democrat and a woman, and the president was advised that it would not maybe look good if he were to federalize an incident, go in with the Insurrection Act and take over the response to Hurricane Katrina. The storm had already done its damage, so now it was recovery, terrible law enforcement problems there, a lot of people suffering from exposure and from being out of their homes and water for several days. Food and medicine were a major problem there. So he sent a small force, but instead of confronting the governor, who didn't want to hand over complete control of the response to the feds, he sent the small force, and the governor continued to coordinate National Guard from Louisiana as well as Mississippi and other states. And the overall grade of the federal role in responding to Katrina was probably an F or maybe a D. And soon thereafter, the president grumbled that he could have used more authority to federalize the incident without having to lock horns, if you will, with a Democratic female governor from Louisiana. So Congress amended the law to change the thresholds and to, I guess you would say, modernize them, to take into account natural disasters and the like that could create an emergency. But it really did flip the assumptions of how the government would respond to crises and make it more likely that the federal response would be first, would be top-heavy, would dominate in many instances. And that was anathema to the states. The governors all reacted very vocally to the change in the law in 2006. All the adjutant generals of the 50 states went on record as being opposed to the revised laws. So 1 year later, Congress said, never mind. And they basically restored the language that we see today and that had really been around since the Civil War era and really since 1790s.
That is remarkable that all 50 governors in 2006 opposed the expansion of the act and that Congress immediately responded. Laura, having so carefully worked our way up to the present, we've now earned the right to address the question of the moment. And I love both of your thoughts on that. If President Trump does invoke the Insurrection Act over the objection of governors to put down examples of domestic violence that don't rise to the level of insurrection, would that be consistent with the statutory language or not? In other words, can he do it?
Well, I think there's an argument to be made that it would not be consistent with the language and it would be going beyond certainly how it has historically been invoked. And I do just want to note about those instances, like the strike-breaking instances that were mentioned, that I don't kind of agree as a policy matter with the way the act was invoked. But I do think that the factual predicate on the ground, the level of violence and so forth, kind of supports the use of the president's authority there as within the statute. I think the way that it's being proposed here, at least based on the facts on the ground, as I understand them, is to be used. It could be used broadly across multiple states to do sort of relatively ordinary civilian law enforcement when you don't have a situation where law and order has completely broken down. Yes, there are some reported instances of violence at these protests, people slashing tires, putting sugar in people's cars, right? Local law enforcement is dealing with this. It's obviously, all violence should be condemned. But I would argue this is not the kind of violence that is understood to be a complete breakdown in law and order that the statute has been interpreted to cover. Now, it's true, the words of the act could be read more broadly. And so someone could differ with me, but I would note that my interpretation is what, again, the U.S. Department of Justice Office of Legal Counsel has consistently said in the memos that are public, that are made public, about how that language should be read. So if you have protests that are mostly peaceful, that's not the kind of situation where law and order is completely broken down that the act, I would argue, is meant to cover. Now, I will note that there's another issue here, which is, well, if that's the case, is that enforceable in court? And of course, there is a tradition of deference to the president when interpreting certain types of statutory authorities that pertain to national security and emergencies. And there's a case at Martin v. Mott in which the president's authority to use the precursor to the Insurrection Act was the subject of litigation, and the court sort of spoke about the importance of deferring to the president's interpretation as to whether the conditions were met. However, I would note that, this kind of deference to the president is not necessarily unlimited, right? And so courts have checked the authority of the executive with respect to statutory interpretation in a number of cases. So I don't think this is an absolute bar to judicial consideration of the issue, but I will note that courts are going to differ here, and many of them may opt in favor of just deferring to the president's interpretation.
Thank you so much for that argument that although the statutory language of 253 is broad, you note that an Office of Legal Counsel memo says that although the act may appear to confer broad authority, there are limits imposed by the Constitution and by tradition, and then you note the questions about whether that would be judicially enforceable. Bill, same question to you. If President Trump does invoke the Insurrection Act to put down domestic violence over state governors' objections that doesn't rise to the level of insurrection itself, would that be legal and consistent with the statutory language or not?
I agree with Laura that it would not, but I'm doubtful that about two things. I'm doubtful that the lawyers who are advising the president would advise the way the OLC has historically advised presidents about the reach of the law. I think they would provide the legal advice that the president's looking for, that is, that he has carte blanche. And second, I think that it's highly unlikely that a court would stop him. I think what's going on now, what's been going on for several weeks, even months, starting in Los Angeles, with courts questioning the guard deployments, that's been a really, I think, useful experience in our democracy to see judges trying to evaluate the efficacy, the legality of presidential invocations of authority in California and now in Oregon and Illinois and who knows where else. Washington's a different case, of course, because D.C.'s not state. But I think if the Insurrection Act is brought to bear I think the president has been advised, even before this term, he was advised before, at least as part of Project 2025, that's a big gun and you can use it, Mr. President. And we're going to make it as seamless as possible if you're ready to invoke the act. As you all know, he wanted to study invocation of the Insurrection Act in his inaugural address. His executive orders on January 20th included instructing his Attorney General and his Secretary of Defense to offer recommendations on invoking the Insurrection Act. That was 9 months ago. And they haven't pulled the trigger yet, but it seems as though they're getting close. There are frustrations from being pushed back by the lower court judges, district court judges, and Court of Appeals to some degree on the National Guard deployments, federalizing the response. I think it's a terrible development in our democracy and a threat to our federalism and to the prerogatives of our states, who are doing just fine in Oregon, California, Oregon, and Washington, and Illinois, rather, without a federal presence. And indeed, in Illinois, I think a lot of people persuasively argued that the presence, the heavy-handed presence of the feds there, constituted the violence, that the citizens of Illinois and law enforcement in Illinois were doing reasonably well before the feds arrived in such large numbers with such an aggressive posture. So I'm not optimistic. I'm worried. I'm worried sick about invocation of the act because it's such a cudgel, and it can be used to such a destructive effect. We in the United States have always wanted our laws to be enforced by cops, by civilians, by the police who are members of our communities. As Laura pointed out a little while ago, the soldiers don't receive training in interacting with civilians. They don't receive law enforcement training. They don't know the Fourth Amendment, the Fifth Amendment, the Sixth Amendment. They're not schooled. And they may be very well-intended soldiers doing their job, but their jobs are not to guard against civilian breaches of civil liberties. So color me worried.
Thank you so much for that. Laura, last word in this deep and important discussion is to you. You note that during the first Trump administration, Attorney General Barr advised against the use of the act to respond to protests that erupted after the death of George Floyd, and General Milley recoiled at the idea of deploying the military under the act, saying it should only be deployed as a last resort. If you were making the argument on the other side, what do you imagine the president's lawyers in the second administration told him about the history of the act that could justify its use for domestic law enforcement? And then please sum up by reminding our listeners why you think that would be a bad idea.
Well, I think it's quite likely that some of his advisors have told him that the act is very broad in the way it's written, and so it gives him a lot of authority. I would imagine that there are people, even in this second administration, that are counseling him against using it, because I would note that he has not invoked it, despite indicating that he wanted to. He's not invoked it yet. That's not to say he won't. But I do think that is significant. I think it would be an extreme measure, even beyond what we've seen. Of course, the federalized National Guard, the use of the military thus far, is kind of under a different basis. And the Posse Comitatus Act, which prohibits essentially direct law enforcement by the federalized military, is in play. Judge Breyer, in his opinion in Newsom v. Trump, concluded that with respect to 10 U.S.C. 12406, which is the statutory authority that the president used to federalize the National Guard and send it to L.A., as well as now Oregon and Illinois. So, using the Insurrection Act would be a way to clearly enable federalized military to do direct law enforcement. And again, I think that that's contrary to our tradition. I think there's a case to be made that doing it in these circumstances would exceed sort of how the act should be interpreted against the constitutional backdrop and alongside history. But I think there is broad language in the act that he might rely on. I do also want to note that there are tremendous practical problems, some of which both Bill and I have alluded to with respect to the fact that the military are really not well trained to do law enforcement. And obviously that's a concern for individuals on the ground because, of course, the Constitution still applies. The Bill of Rights still applies. Anything the military does by way of law enforcement directly still has to respect people's Fourth, Fifth, all their amendment rights. And again, the military doesn't get training in this. So there is a real risk that people's rights could be abused. Again, even if the military are extremely well-intentioned about this and extremely cautious about this, it puts people's rights at risk. But I want to note that it also puts the military at risk. The military is one of the few institutions in our society right now that enjoys broad bipartisan support. And it does a tremendous job protecting us both at home and abroad. Our men and women in uniform deserve that tremendous respect. But if you put them into these volatile, politicized situations, that respect, there's a strong likelihood that respect will be eroded. And already we're seeing sort of in the places where the military has been used, even under these other authorities, disrespect of the military. So it puts them in a really difficult position. Of course, it puts them also in a difficult position because if they are asked to do things that they're not well trained for, they may be in a position of violating the law. And yet they must follow orders. So I would say it puts them on a knife's edge. And I would say it's really not good use of our military, who should be used for other more important purposes.
Thank you so much, William Banks and Laura Dickinson, for a deep, comprehensive, and important conversation about the history and potential current deployment of the Insurrection Act. Bill, Laura, thank you so much for joining.
Thank you.
Thank you.
This episode was produced by Bill Pollack and Griffin Ritchie. It was engineered by Bill Pollack. Research was provided by Griffin Ritchie, Trey Sullivan, and Tristan Worsham. Friends, I'm so excited that my new book is coming out in October. It's called The Pursuit of Liberty: How Hamilton versus Jefferson Ignited the Lasting Battle Over Power in America. Please pre-order online today, and if you'd like a signed book plate, please write to me at jrosen@constitutioncenter.org. Thanks so much for checking the book out, and can't wait to hear what you think. Always remember that the National Constitution Center is a private nonprofit. We rely on your generosity, passion, and engagement for all our programming. Please consider donating at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Jeffrey Rosen.